You see, this accused, he was sentenced for 7 years. And that he was transferred from the district jail Lungle to Aizawl, Central Jail Aizawl on 6/4/2018. And upon completion of the term, he was released from jail on 14/10/2022. So this perhaps was not known to any one of us. You also did not assist me on this issue. Having regard to the term of 7 years, it was probable that it might have been over by now. So that's why I got it inquired. It turned out that he has been released already in 2022. So what would happen under the circumstance? Now, if the court finds no merit in the appeal, then it's dismissed. But if the court finds merit in the appeal, then what happens? There was a mention about some POCSO case.
Yes.
There also probably it's not a very serious offense in the sense that he's already out. That means the sentence was quite minimal.
Yes.
So I thought I'll bring this to your knowledge, both of you, under the circumstances. We'll have to take a call this way or that way. It's already reserved for judgment. We've heard the parties, no doubt. But except for this point, that he's already out. Now, if the court finds merit in the appeal, then what would happen, Mr. F. Lelengden? What will have to be done?
My lord, so far as my understanding is, my humble opinion, if the Honorable Court finds merit in the appeal and fresh proceeding, the matter can be reverted back to the trial court for fresh trial, my lord. But in this case, the situation is that if the victim, I mean the convict petitioner was already released on completion of the.
No, there is no lacuna. Probably there's no lacuna in the trial. So it may not be a case of fresh trial, per se.
Yes.
It would be for reconsideration. See, I think the appeal is under 377. So, under the circumstance, if the court is of the opinion that the sentence passed was inadequate, then invariably an opportunity to show cause has to be given to the accused person. 377, I think, subsection 5, something. And he will have to be given a chance. So this is the thing. So now you know what is what. He's out. If you have anything to add, you let me know. Otherwise, we'll have an order very soon.
My lord.
Okay. Okay. Next item, please.
Motion item 2.
Any mention?
Yes, Your Lordship. If I may, my Lordship. This in respect of this item number 12 and 13 of today's hearing,
Yes.
the
12 and
last two
13.
items. If this matter may be kindly passed over for the day, I had bereavement in yesterday, so I could not
If
prepare.
it's passed over, he'll come back again tomorrow.
If possible, my Lord.
But tomorrow may not be possible.
All right.
There's benches available just tomorrow. So
We can have it
the last
anytime.
working day, you would not like to leave something.
Of course, Your Lordship. If possible, next week, Your Lordship.
Okay, as paid for by Mr. Lal Fakoma, learned counsel for the petitioners,
Yes.
and not objected to by the other side. List the matter again in the next week
My lord, if we can have a fixed date,
22 if possible, my Lord.
on 22nd. Yeah?
Thursday.
Thursday. On 22nd of, okay, instead of next week, you said list the matter again. List the matter for hearing on 22nd 5/2025.
Deeply
Okay.
obliged.
I seek my lordship indulging on item number 10 of the listed column.
Yes.
Though, my lord, though the item is fixed for today, my senior, Eke Rokum, is having personal difficulties.
Okay,
May this matter be listed after a week.
after a week.
I
Okay.
take a consent from the opposite party, my lord.
You are there for the other side. You have objection?
No, my lord.
Why don't you object? This is your chance to object. Anyway, see, there's something called SLP which is connected with this case. At one point of time, matter was adjourned on the ground that SLP is pending on similar issue. It was adjourned. Later on, somebody said that SLP is already disposed of. But nobody has bothered to produce the copy of the SLP. We don't know what is what. Are you aware about this?
My lord, I think it might be appropriate if my seniors is turning on next week for.
Don't depend on your senior every time. You also do some research.
Yes, my lord.
You,
Yes,
you want to stay with your senior throughout your practice.
no, my lord.
Then?
I'm well aware
Why
of
don't
that.
you start learning?
I'm
And you just pick up the brief and say, I'll make a mention, but let me know the facts. What to do. Court will ask questions. You cannot answer. Court will be angry, annoyed. Then you will not get a favorable order. You should have a look out for that also.
Yes, my lord.
So when? Next week?
If possible, my lord.
Next week?
Yes.
Okay. Mr. A.K. Rokum, Learned Counsel for the petitioner is said to have some personal difficulty to appear before the court today on a prayer made on his behalf and objected to by the other side. The matter stands adjourned for a week. The learned counsel for the parties shall produce a copy of the order passed by the Honorable Apex Court in an SLP which is said to be connected, which is said to cover the instant case on the next date. All right, please find out the order, produce it.
Motion item 2.
Yes,
Lordship. This is a writ petition filed under Article 226 of the Constitution of India, Lordship.
okay.
I am the Associate Professor in NIT Mizoram. And the alleged fact-finding committee passed the impugn order against me on 31st January 2025. And your Lordship, the impugn order is found at page number 29, Lordship.
Now, who are you?
I am the Associate Professor, Lordship,
Associate Professor,
Associate Professor.
in the NIT.
in NIT, Lordship.
Now, what is your complaint?
Yes, my complaint is against the impugn order that is at page number 29, Your Lordship. May
Page 29?
29, Lordship.
What has happened to you?
Yes, Lordship. I'm reading, Lordship. It's a very short one.
Yes.
Pursuant to the decision of the competent authority of the Institute, which is in line with the multiple complaints received from the research scholars against Dr. B.J. Yananda Mohanty. This is the petitioner, Lordship. Associate Professor, Department of Civil Engineering, NIT Mizoram, regarding verbal and mental harassment to the PhD scholars in Department of Civil Engineering. A disciplinary action is hereby taken against Dr. B.J. Yananda Mohanty, Associate Professor, Department of Civil Engineering, NIT Mizoram, as under. Number 1, Dr. B.J. Yananda Mohanty, Associate Professor, Department of Civil Engineering, NIT Mizoram, shall not be allotted any new research scholar for the next 3 academic years or till further orders, whichever is earlier. Number 2, Dr. B.J. Yananda Mohanty shall refrain from causing such mental harassment to his research scholars and must not threaten any of the research scholars. Number 3, if the institute receives further complaints against him, stern disciplinary action may be taken, leading to even expulsion from the institute. Lordship, this particular impugn order is passed against me without following any procedures, Lordship. So the brief facts is shortlisted at page number 16, Lordship. May I kindly take you at page number 16 of the petition? Page number 16, Lordship.
Yes.
Para 14. I'm reading, Lordship. This is
Yes.
a very brief one. That by an email, date 29/1/2025, the respondent number 3, that is the registrar, informed the petitioner to appear before the fact-finding committee on 29 itself, Your Lordship, at the office of the registrar, NIT, Mizoram,
What do you mean on 29 itself?
Lordship, the meaning is that
29 is 29. What do you mean on 29 itself? Are you
On the
trying to
same
imply
day.
something?
Lordship, I was informed to appear before the committee.
The order impugn is passed on 31st January.
Lordship,
This is 2 days before that.
Lordship,
Okay, please read.
Lordship. Before the fact-finding committee on 29/1/2025 at the office of the registrar, NIT Mizoram, at 5:15 p.m. The information was given via email on 29/1/2025, 11:14 a.m. The email runs as, based on the complaint received, you are hereby informed to appear before the fact-finding committee on 29/1/2025 at the office of registrar, NIT Mizoram, at 5:15 p.m. However, the petitioner was not made aware of such allegations. As such, he replied the email on the same day at 11:24, requesting the respondent number 3 to attach the complaint what he received. The reply runs as, can you please attach the complaint what you have received? I need to go through it before appearing. As the petitioner's request was not replied, he again on the same day at 5:13 p.m. sent a letter via email to the respondent number 2, that is the director, herein stating that it was a clear violation of the principle of natural justice as he was not made aware of the allegations. The email runs as requested by me in the trailing email, I have not received a copy of the complaint yet. That is, it seems to be a clear case of violation of the principle of natural justice. This is to state that the whole day I was not in a position to concentrate on my important assignments, working at the level of the associate professor in the Institute of National Importance, that is NIT Mizoram. Again, it seems the complaint is false and prefabricated, and the act is a clear case of mental harassment to me. In these circumstances, I am not in a position to appear myself. I should not appear myself as intimated. This is for your information and necessary action, please. And the next page is, in reply, the respondent number 3 informed the petitioner via email on the same day at 7:03 p.m., stating that the complaint could not be shared over mail as they needed to protect the identity of the complainant. He informed the petitioner to appear before the committee on 30/1/2025, 4 p.m. The respondent number 3 on 30/1/2025.
Okay, Mr. Anunciama. So ultimately we appeared.
I appeared, Lordship.
Then what transpired in the meeting?
Lordship, during the discussions, I personally asked the authority to furnish what kind of complaints was against me.
You were not given.
I was not given,
Then
Lordship.
what did they tell you? What was the complaint about?
Lordship, belatedly, I came to know that the complaint was something like harassment against some research scholars, Your
So
Lordship.
that's in the order itself. Impugn order says that.
Lordship, yes.
So in
I
the
found
meeting,
it.
what happened? What did they tell you?
In the meeting, Your Lordship, I was asking the authority to furnish a copy, but they declined.
That you said already. Then they don't give you. Then what did they say?
Lordship, I submitted before the authority that it was just a personal grudge, as there was some sort of complaints 2-3 years back, in which I was exonerated from the complaint, from the case. So, Lordship, that is the
Earlier there was a complaint.
earlier, Lordship, yes.
Okay.
So-
on same issue. On
On same
harassment.
issue, Lordship.
On harassment.
Lordship. Lordship. So my case at present is that I was not given the proper opportunity of being heard in presenting my case. And if there is some complaint against me for passing such kind of impugn order, there must be some disciplinary proceedings initiated as per law, Your Lordship,
Okay.
without following proper procedures.
All right. So you're basically challenging this order.
Lordship.
So what can be done at this stage? Will you issue notice?
And Lordship, in the interim, a stay may kindly be granted.
Will you issue notice on
Lordship.
On both interim also, if you want to. We
Not
issue
safe,
notice. We have to hear the other side also.
not safe.
Heard Mr. Tilal Nunsiama, learned counsel for the petitioner, who submits that the petitioner, who is an associate professor of NIT what? Mizoram?
National Institute of Technology, Mizoram.
NIT Mizoram
Not safe.
has been issued the impugn order dated 31/1/2025. By which it has been directed that he shall not be allotted any new research scholar for the next 3 academic years or until further orders, whichever is earlier. Stop. He has also been warned to refrain from causing any such mental harassment to his research scholars and not threaten them. Further, if the institute receives further complaint, disciplinary action will be taken against him. Next para, the learned counsel submits that without giving the petitioner any opportunity or giving a copy of the complaint which was submitted against him, the respondent authorities have passed the impugn order, and therefore the same should be set aside. Next para, issue notice returnable by notice of motion returnable by 4 weeks. Petitioner to take steps for service of notice upon the respondents by registered post with ADDU within 3 days. 3 working days. Then next para, also issue notice on the interim prayer returnable by 4 weeks as well. List the matter again after 4 weeks.
Much obliged, Your Lordship.
Item 3.
Lordship, this matter is being filed by the last validly appointed CEM of the LADC, my lords. Normally when a CEM is appointed, in this particular term, the CEM staked his claim in January, my lords. Then the governor called for a floor meeting to prove his majority, and ultimately he was appointed on 24th February, my lords. Thereafter, he did not have an opportunity to prove his majority on the floor. In the meanwhile, one of the members of his own executive committee had defected to another party, my lords. So what the governor ought to have done was to call for a fresh opportunity to prove his majority on the floor under 33(6), my lords. However, that wasn't done. In fact, what the governor had done is he appointed the respondent number 5 on 2nd May. And then he realized that there were 2 appointments at the same time. I was also the CEM and also respondent number 5 was the CEM. So on 7th May, as an afterthought, he declares my appointment of 24th of February as null and void. So my grievance, my lords, is that the entire procedure that has been followed by the governor is not in accordance with the law, my lords. And in these gubernatorial matters, the governor's procedure is very strict. And what is under review, my lords, judicial review, is the manner in which the decision has been arrived at. So the manner in which this decision has been arrived at is completely devoid of all the processes established by the LADC conduct of business rules and also the constitution, my lord.
Let us see where is your appointment as CM.
24th Feb.
Given the book rules.
Lordship, 24th Feb letter, annexure 6, my lords. Lordship will find it at page 72.
This is your appointment.
Yes, my lord.
You're appointed under sub-rule 4 of Rule 21.
Yes, my lords.
Then under sub-rule 5 of Rule 21, you have to prove your majority.
Lordships.
A vote of confidence.
Yes.
Secure a vote of confidence within 30 days.
That's right, my lords.
So what happened?
Lordship,
Did you secure it?
I haven't secured it. I haven't secured it. The reason being it was to be held on 18th of March. On that very same day, the chairman and deputy chairman resigned. So it could not be held. So I took all steps in my power and position and asked for on 19th May that please appoint a pro tem speaker. And that was done much later. Thereafter, it was again called for. My lord. But in the meanwhile, the new chairman issued a agenda calling for the budget, etc. And the meeting was held, my lords. But the responsibility was on the chairman, my lords, to call for the meeting, and it wasn't called for. After the budget was passed on 22nd, the governor said, "What all you did is wrong, so you please stop proceeding with your business," and the chairman adjourned the matter sine die, my lords, thereafter. So it's beyond my control, my lords. But my submission, my lords, if your lordship may look at page, look at the appointment of the new member, my lords, respondent number 5, which is at page 113, my lords. Second May, has lordship got it?
Yes.
Lordship, here they are appointing Mr. N. Zangura, the respondent number 5, my lords. On this date, I was also the chief executive member, my lords, on this very same date. So the governor had no responsibility. The governor's job, in case Mr. Zangura was claiming to be the CEM, he should have been called for a floor test. The only thing the governor could have done, my lords, in these circumstances was to call for a floor test. Lordship may look at the rules, my lords, if lordship doesn't mind.
Why should I mind? You should show me the rules.
Lordship.
We all go by the rules. It's not what I like or what you like. Things will follow like that. We have to go by the rules, by the law.
Lordship, what I meant was at this stage, I would have
Sure,
shown you
sure,
anything.
sure. What are the
Lordship,
rules?
I would request Lordship to look at Rule 32, my lords.
32.
Yes, my lord.
Election of deputy chairman.
Summoning of district council, my lords. District council session, conduct of business thereof, general.
Just a minute. 32, you said.
Yes, my lords. What was the right rules?
Summoning of district council.
Yes, my lords.
Yes.
This talks of the first meeting, my lords. 32(1). It talks of district council for its first meeting after the general election shall be summoned by the governor.
Yes.
Rule 2 says for all subsequent meetings, subject to the provisions of Rule 4, the chairman in his absence, the deputy chairman shall summon the district council, my lords. Rule 3 talks of notice. Rule 4 talks of how many times it shall meet in the year, my lords. Rule 5, my lords, is relevant for the point of saying that also they may prorogue a session of the council, and this was done on 22nd of April. And Rule 6 only says, notwithstanding anything contained in this rule, nothing shall restrict the power of the governor to summon a meeting of the district council at any time as he may think fit in public interest. So
Now, why are you showing me this provision?
my submission, my lords, is the only thing the governor could have done was to summon a session under Rule 6. He could not have gone on his own and appointed a new CEM, my lords. The rules don't provide for that. He could not have
Summon a meeting for what purpose?
Summon a meeting then to prove the majority or for whatever purpose. my
See,
lord.
your appointment you have shown me, it
Yes,
says
my
1 month.
1 month.
Within 1 month, nothing was happened.
Yes, my lord.
You said somehow the chairman or deputy chairman,
Yes,
they
my lord.
resigned.
Yes, my lord.
Pro tem was appointed.
Yeah.
Then after the pro tem was appointed, perhaps the new chairman, vice chairman,
He
Where
went
upon
ahead with the
deputy
budget
chairman.
session, my lord.
he headed the budget session.
Yes, my lord.
Insofar as your securing majority remained redundant, it remained as it is.
Yes, my lord.
So in such circumstance, what would happen?
In such circumstances, the governor had no right to appoint someone else. The governor has no right. I will show my lords the 7th May order. It declares my 24th February letter as null and void. The governor had no such powers. Governor had only the power to summon a session of the district council, summon a meeting of the district council.
The budgets were passed.
Budgets were passed. Passed, but the governor said, no, these should not be.
But the leader of the house, the CM,
Yes, my lord. Sorry, my lord?
the CM is the leader of the house.
Yes, my lord.
So he had not secured the vote of confidence.
Yes, my lord. I'm not on that at all, my lord.
No. Without the CM commanding majority, could the budget session be held in such a manner?
Lordship, any such question can't be raised by the governor, my lord. Any such question on the procedure or point of order could only be raised by another member, and there is a process for that. The process, my lords, is there under Rule 50 and 51, my lord. It's a point of order. And if anyone had a doubt about the confidence, they had to move only under 83, my lords, which is the motion of no confidence. Governor had no such role to play, my lords. The role of the governor is not to get into all this.
You're referring to Rule 50.
Rule 50, my lords, is whether proceedings are valid or invalid, my lords.
This is to be raised by the member.
Yes, my lord. Raised by a member. And if there was no confidence of the CEM at that time when the budget was passed, only recourse is 83, my lords.
83.
83.
83 is... Please read 83. What does it say?
A motion expressing want of confidence in the executive committee or a motion disapproving the policy of the executive committee in regard to any particular matter may be made with the consent of the chairman and subject to the restriction that the member making motion shall present to the secretary a written notice of the motion before the commencement of the sitting of the day. If the chairman is of the opinion that the motion is in order, he shall read the motion to the council and shall request those members who are in favor of leave being granted to raise in their places, and if not, less than 1/4 of the members present rise accordingly. The chairman shall intimate that the leave is granted and that the motion will be taken on such day, not being more than 2 days and not less than 24 hours from the time at which leave is asked for, as he may appoint. Provided that if the exigencies of the business require, the chairman shall have the power to relax the rule and take up the motion earlier than 24 hours.
Not being more than 2 days from the date of the application.
Yes, my lords. But so far, no application has been made, my lords, by anyone.
Not being more than 2 days and not less than 24 hours for the time which leave is asked as he may appoint. Chairman has the power to relax
Grateful.
and take up the motion earlier than 24 hours. If less than 1/4 of the members present rise, if less than 1/4 of the members present rise, the chairman shall inform the member that he has not the leave of the council. This is regarding what?
This is regarding expressing bond of confidence in the executive.
Motion of no confidence.
Yes, my lords.
So if less than 1/4 of the members do not rise, if rise,
Right.
then it is not a majority. So the chairman will ignore it.
Yes. That means basically it means that 25% is required.
1/3 has the 1/3 has the confidence.
1/4, my lords.
The 1/4 is not less than 1/4. Okay. If less than 1/4 rise to support the motion, is it?
Yes.
Then he'll ignore the motion.
That means basically 25% is required. my lords.
So you're saying that this procedure should have been adopted.
Grateful, man. I'm saying this procedure, and it's not for the governor to take these steps. Because if Lordship, I will read the other orders of the governor. He's acting based on information received. A governor cannot act based on information received. He has to act either on the aid and advice of the Council of Ministers or on some cogent reasons, and if he should have some discretion. And in matters where it is a motion of no confidence, then he has no discretion, my lords, to act on his own.
So summoning of the district council at the first instance would be after the election, would be the governor.
Yes.
And subsequent meetings can be called by the
Yes.
chairman.
Yes.
And subsection 6 also provides again that there's no restriction on the governor to summon a meeting.
Yes. So
Are
at,
you-
at best, he could have summoned a meeting. He could not have said, "No, Mr. Petitioner, you're out, and I put this new man in place." That is completely improper.
But what would happen to your vote of confidence?
Vote of confidence.
Without vote of confidence, do you remain like that? What does the rule say?
Lordship, then I again rely on 83, my lord. If there is a vote of confidence, members should make a move and come under 83. These are protected by 6th schedule, my lord. So the governor can't override the rules. Amendment 23.
Your appointment is under sub rule 4.
Yes, my lord.
Sub rule 5 says that, of 21 says that 30 days.
Yes, it does say 30.
If the governor may, if he considers necessary, cause the district council so and so. Then what are the further provision? Supposing you don't secure the thing, you're out.
It is silent, my lords. I've studied the whole rules. There's nothing silent, and I think only the recourse would be 83, my lords.
If 30 days lapse, then what happens?
There's it's silent, my lords. The law is silent on that. The only recourse is 83.
83. Who is to present this motion? A motion expressing want of confidence in the so-and-so or motion disproving so-and-so in regard to any particular matter may be made with the consent of the chairman and subject to the restriction that the member making such motion. Member making such motion shall present to that secretary a written notice of the motion before the commencement of the committee sitting of the day. Anyone appearing for the opposite party at this stage? No. They don't have a standing counsel.
Yes, my lord. I'm for respondent number 4.
Who is respondent number 4?
LADC.
Sorry?
I'm for respondent number 4.
Who is respondent number 4?
LADC, my lord.
Yes. What do you say? What is it? You have received a copy?
Yes, my lord.
Are you a standing counsel?
Yes, my lord.
Okay. What is the instruction?
Lordship, in this particular case, I received just only yesterday. However, as rightly mentioned in the petition, please, Lordship, it is on page 11. Similar situation has occurred previously, even during the appointment of the petitioner as CEM. 13 members, ZPM Legislature Party requested the governor for approval of an emergency session to enable floor test. However, Lordship, the predecessor CEM Lal Muantanga submitted his resignation. So the governor sent a letter to conduct floor tests to the petitioners herein. However, without conducting any floor test, the petitioners herein presumed that they could continue with their government. So, as it was clearly provided in the appointment letter of CEM Vizier Sangha, we can see that as provided under sub-rule 5 of Rule 21 of the Lai Autonomous District Council, Constitution, Conduct of Business, etc. rules, the governor of Mizoram directs the chief executive member, who is the petitioner herein, to secure vote of confidence within 30 days. However, floor test nor vote of confidence was not met. So
then what? Then you start appointing some more CM during the subsistence of that order.
Lordship,
See, one thing which I don't understand is, you may be right. He has not got the floor test, so he has no right. But the thing is that, first of all, you should clear the place. He is still the CM. See, the appointment of the private respondent number 4 or 5?
Five.
5 was made on 2nd May. As on 2nd May, petitioner was also the CM,
Yes, Lordship.
minus the flow test, of course. But he was a CM. Could you have appointed another CM on 2nd May? Then later on 7th May, you just discard him. You say that no, everything is declared null and void. Show me the provision in the rules where it says that if you don't get the flow test, you are out.
There is no rule for that, Lordship.
Then?
However, Lordship, even previously, the petitioner and other companions, other members, also informed the governor that they could secure majority. Similarly, even in this instance, N. Zangura and other members informed the governor that they could form the government.
So petitioner is an elected leader
Grateful, my lord.
of this ZPM legislature party.
Yes, my lord.
Then being the elected leader, he has been appointed as the CM.
Grateful, my lord.
And only thing now the governor says is that you are appointed, but now you show me the
Flow test.
flow test. Flow test did not happen because of this or that reason.
Yes.
But the district council session was called
Yes, my lord.
by the new chairman.
New chairman.
Budget was passed.
Grateful, my lord.
What happens to the budget then?
Lordship, that
The
is the
CM
question, my lord.
The CM has not proved that he has the confidence of the house.
Lordship, also I just want to show how at page 115 my appointment was declared null and void. And then it also, the governor goes ahead and says that there should be no legislative or administrative business to be carried out. And it also says that the budget passed should not be acted
Correct.
upon.
That is what you have impugned.
Sorry, my lord?
That is what you have impugned, isn't it?
Yes, my lord.
So the view taken is that since you have not passed the flow test, so whatever proceedings which happened
Yes,
in the house
Yes, my lord.
is null and void. And
That's
before
right, my lord.
securing such kind of confidence, no further decisions should be taken. No business,
Yes, my lord.
administrative, executive decisions should be taken.
Yes, my lord. But I am also protected in that front, my lords, because Lordship may look at Rule 49. Rule 49. Then Rule 50, my lords. The budget, according to me, is still valid.
Rule 49.
Rule 50, my lords. Rule 50.
50. Yes.
No proceedings of the district council shall be deemed to be or ever have been invalid by reason of any rule not being or not having been complied with, but in case of any such non-compliance, a member may raise a point of order. Still, the governor has no say in this matter, my lords. Only it comes to the members, my lords, the elected members. This is how the democracy was envisaged when this was drafted, my lords. And not a single member has objected till today. Not a point of order has been raised, my lords. But my difficulty, my lord, tomorrow they asked the respondent number 5 to conduct a floor test. My submission is that this should not happen because, first of all, the manner in which the action has been taken by the governor is wrong. I continue to be the CEM. Therefore, any action should not be taken till this issue of how these two orders of 5th May, 2nd May and 7th May are dealt with in detail by this court, my lords.
So as of today, who's the CM?
Lordship, it should be the petitioner, my lords.
Petitioner, despite the appointment being declared as null and void, and a respondent number 5 having already been appointed. The legality or otherwise of this action has to be examined.
Grateful, my lords. It
And
requires consideration.
at this stage, you cannot say that I am the one who is holding the post because that order has already been passed.
Yes, my lords.
So we'll issue notice. Yes, Lordship.
Lordship, in the meanwhile, tomorrow's floor test, my lord, should not happen. I've sought stay, it's at page 122, my lords. At least that should be stayed, my lords. Otherwise, the whole petition will become infructuous.
122.
122, annexure P29, my lords.
You're Mr.
I am Robin Ratnakar David, my lords.
Hurt Mr. R.R.
David.
Learned counsel for the petitioner, who submits that by filing this writ petition, the petitioner has challenged the notification dated 2/5/2025, bracket annexure 22, comma, notification dated 7/5/2025, bracket annexure 23, and notification dated 8/5/2025, bracket annexure 29.
Yeah.
Any other notification?
Lordship, actually, as a consequence of 2/5, several notifications have been passed. So, as a consequence,
And the consequential action taken pursuant to the issuance of the said notifications. Now, the learned counsel submits that the petitioner, who is an elected
page 72.
MDC from Pythar MDC constituency and also an elected leader of the ZPM legislature party of the LADC was appointed as the chief executive member, bracket CM, close bracket, of the LADC with effect from 24/2/2025. White notification dated 24/2/2025, bracket annexure 6. Full stop. The said appointment was made in terms of Rule 21, bracket 4 of the Law Autonomous District Council, open bracket, Constitution, comma, conduct of business, etc., close bracket, rules, comma, 2010. Open bracket, CCB rules, close bracket, full stop. By the same notification, it was provided that the petitioner should secure the vote of confidence within 30 days from the date of the appointment, as per Rule 21 bracket 5 of the CCB rules. Stop following his appointment. A session was summoned by the This was summoned by the governor.
It was summoned.
No, it was summoned by the chairman. Was summoned by the chairman, LADC, on 18/3/2025 at 10:30 a.m. What is the purpose of this summon?
To secure a vote of confidence.
To have the flow test. Okay.
Yes, yes, ma'am.
White notification dated 4/3/2025, bracket annexure 7. Stop. However, before the session could be held, comma, the chairman as well as the deputy chairman submitted their resignation. And in the result, comma, no session could be held on the fixed date. Stop. Subsequently, a pro tem speaker or pro tem chairman, is it?
Pro tem chairman.
Pro tem chairman was appointed for appointing for
Appointing a chairman.
for the purpose of chairing the session to appoint the new chairman and deputy chairman. Who was appointed? Chairman. Where is that appointment?
Lordship, at page 85, annexure P12, annexure 12. And this appointment was made at my request only, petitioner's request.
No, this is the pro tem chairman.
Pro tem chairman.
No, the pro tem chairman we have already said. Now after the pro tem chairman, the regular chairman has been appointed.
Yes, my lord.
Where is that?
Page 89, annexure 14.
Stop. Subsequently, one Sri T. Zakuma was elected as the chairman. And what of the vice deputy chairman?
He was subsequently appointed, my lord.
Who is he?
Not at that.
Who is he?
The same seat I'll be examining.
Okay. So what did I say? And Srimati C. Biak Thansangi was appointed as the deputy chairman. Stop. The new chairman, white notification dated 2/4/2025. in exercise of the powers conferred upon him by Rule 32, bracket 4 of the CCB rules, summoned the 11th Lie Autonomous District Council to sit for its emergency session commencing from 17/4/2025 at 10:30 am. Stop. It was notified that no other business except discussion on the LADC budget for the year 2025-2026 and the election of the deputy chairman would be taken up. Then we'll have to rephrase that
Yes.
earlier part. Stop. The budget session was accordingly held, and Srimati Byakhan Sang, is it? Was appointed as the deputy chairman. So the earlier part, you should strike out that appointment of deputy chairman, okay? The last, the one which I just dictated, that'll stay. Where's the thing? Declaration of the session as sine die? All these happened after the issuance
Lordship,
of
there
the...
was a budget session after that, which Lordship will find at page 92, my lords, the budget session. Then thereafter, the budget, my lords. Sanidai, which page?
Suspension of the session,
One.
sine die? Yes, at page, this is 108. This happened on 22nd April.
Yes, my lord.
All these happened prior to the impugn orders.
Yes, my lord. First,
Stop. After the budget session was over, the chairman, LADC, was pleased to prorogue the LADC emergency session on 22/4/2025 at 2:40 p.m. Sine die. Page 108, okay? You'll find this. Just. So the chairman requested for flow test. Is it at page 112A?
yes.
After all the budget session
Yes, he
was
did.
over.
Yes, he did.
Next para, after the budget session was over, the chairman of LADC, White Communication dated 28/4/2025, bracket annexure 21A,
Yeah.
wrote to the governor of Mizoram through the secretary to the government of Mizoram, District Council and Minority Affairs Department,
Yes.
informing that since the period of 30 days for having the flow test had already lapsed, a fresh order for conducting the flow test be
Yeah.
issued in terms of Rule 21, bracket 5 of the CCB rules.
Let's go.
Stop. However, instead of giving further time to have the floor test on the appointment of the petitioner as CM, comma, the respondent number 5 was appointed as the new CM by notification dated 2/5/2025. By the governor in exercise of the powers conferred by Rule 21 bracket 4 of the CCB rules. Stop further. The respondent number 5 was directed to secure vote of confidence within 10 days of his appointment as the CM in terms of Rule 21 bracket 5 of the CCB rules. Stop subsequent thereto, the governor, subsequent thereto, the petitioner, the appointment of the petitioner as CM LADC issued by notification dated 24/2/2025 was declared null and void. White notification dated 7/5/2025. Stop further. The budget for the year 2025-26 presented by the petitioner and passed by the House was also declared null and void. Stop. Also, a restriction was placed that no legislative, business, or administrative / executive decision be taken by the LADC without the newly appointed CM, that is the respondent number 5, proving his majority. So, pursuant to the appointment of respondent number 5 as the CM, the chairman, LADC, white notification dated 8/5/2025, has summoned the 11th LADC to sit for its session on 16/5/2025 at 10:30 a.m. for having a floor test on the appointment of the respondent number 5 as the new CM. Stop. Agreed by the impugn actions. The petition is before this court. Stop. Mr. R.R. David, learned counsel, submits that the respondent number 5 could not have been appointed as the new CM during the subsistence of the appointment of the petitioner as the CM LADC as on 2/5/2025. Stop. Floor test could not be conducted within the prescribed time given on account of the resignation of the chairman and the deputy chairman, LADC. Subsequently, after the appointment of the pro tem chairman, the new chairman was appointed. The governor, in such a situation, would have summoned a meeting as per Rule 32 bracket 6 of the CCB rules. Further, the impugn action of the further, as per the impugn notification dated 7/5/2025, no, you write like this from the cancel. Further, as per Rule 50 and 51 of the CCB rules, no proceeding of the District Council shall be deemed to be invalid unless any member of the District Council submit a point of order for decision of the chairman It is therefore clear that it is not the governor but the member of the District Council who can raise the validity of the proceedings of this session. The learned counsel further submits that the petitioner, having been appointed as the CM LADC, cannot be removed in the manner it has been done, except by a motion presented by the member of the District Council in writing to the Secretary before the commencement of the sitting for the day, in terms of Rule 83 of the CCB rules. In case of the petitioner, no such motion has been moved by any of the member. And the appointment of the respondent number 5 during the subsistence of the appointment of the respondent number appointment of the petitioner as CM LADC is wholly justified, unjustified, illegal, wholly illegal and arbitrary, and therefore the appointment of the respondent number 5 and the other impugn notifications should be set aside by this court. Next para, in view of above, issue notice of motion returnable by 3 weeks.
Your Lordship, my senior Mr. Egerokum has instruction to represent private respondent number 5.
Okay, good. Your good name?
Arlan Munsiama.
Mr. Arlan Munsiama, learned standing counsel, LADC, accepts notice on behalf of the respondent numbers 1, 2, 3, and 4.
No, my lord.
2, 3, and 4.
Only 4.
Respondent number 4. While Ms. Lal Nundui, learned government advocate, accepts notice on behalf of respondent numbers 1, 2, and 3. We'll stop at this stage. Mr.
Nasanki Maralte,
Lalsanki Maralte, learned counsel, submits that you are assisting Mr. Rokum.
yes, my lord.
He has instructions to appear on behalf of the respondent number 5. No, submits that. He writes like this. His senior, Mr. A.K. Rokum, has instructions to appear on behalf of the respondent number 5. And therefore, he will accept notice on behalf of respondent number 5. Full stop. As a result, no formal notice is required upon the respondents since they are all represented today. The petitioner shall furnish requisite copies of the writ petition to the learned counsels appearing for the respondents, if not already done. Next para. Having regard to the fact that the no confidence motion, the floor test in respect of the respondent number 5 is scheduled to be held on 16/5/2025. And at the same time, considering the fact that the respondent number 5 was appointed on 2/5/2025, on which date the appointment of the petitioner subsisted as the CEM LADC. It is hereby directed that until the next returnable date, the impugn notification dated 8/5/2025 shall remain stayed.
Grateful.
List the matter again after 3 weeks.
Can we have fixed date, Your Lordship?
Give a date, 3 weeks.
Yes. 6th of June. What's about 10?
10th of June, all right, fine. 10th of June.
Grateful.
Obliged.
Admission item 4.
My lords, I pay for the petitioner, my lords.
Where's your rejoinder?
My lords, we filed.
When?
My lords, I believe we've already filed in this matter. We filed. Yes, my lords.
That's why I'm asking.
My lords, I'll have to check because my understanding we've already filed long back. My lords. I'll check with the registry.
Mr. Jordan, you should have the habit of looking at the
My lords, my lords.
office notes
Yes, yes, my lords.
before making a submission.
Yes, my lords.
There are two petitions. I mean, two bunch of papers. One is the
Yes.
writ petition. The second one is the counter affidavit.
Yes.
And the third is the office notes. The latest note says that no rejoinder. Check up.
Yes, my lords.
Office note dated 14/5/2025 indicates that rejoinder has not been filed. Mr. Jordan Romingthanga, learned counsel for the petitioner, submits that he is otherwise of the belief that rejoinder had already been filed earlier. He, however, submits that he may be given a week's time
My lords.
to check up the matter, and if the same has not been filed, he will file the same within the given time. Yes.
Good.
Item 5.
This is also no rejoinder.
I'm seeking more further 3 weeks time, my lord. I have filed RTA application to the MADC, which is still not responded by the concerned authority. Both the MADC and the state had already filed their respective affidavit. I would like to file reply.
As prayed for by Mr.
Sir,
Victor L. Ralte, learned counsel for the petitioner, further 3 weeks time is granted for filing rejoinder affidavit.
May it please your lordship, on behalf of the state respondents, I have been given additional information which may be submitted in the form of supplementary affidavit, your lordship. It is if it is regarding a study group that has been constituted by the governor to look into the new defined contributory scheme pension scheme 2010 for the employees of MADC.
Okay, Ms. Lalan Hui, learned government advocate, submits that she has received additional instructions which is relevant to the instant case, and therefore she may be allowed to file an additional counter affidavit. Praise allowed.
Much obliged.
the order of status quo upper study may be continued.
Status quo, interim order passed earlier shall continue till the next date of listing.
Much obliged.
Item 6.
Yes, where is your counter?
Yes, my lord. I'm representing the respondent number 1 to 6, and I'm seeking another 3 weeks' time to file my affidavit in opposition, my lord.
And your friend there?
Yes, my lord, I'm for respondent number 7 and 8. I have filed my affidavit in opposition yesterday.
Okay. How many respondents are there? 7,
My
8.
lords, 7 in all.
8.
8 in all.
8 in all. Sir.
Government advocate represents 1 to 6.
Yes, my lord.
Okay. Although the respondent numbers 7 and 8, represented by Ms. Ruth Lal Ruatfeli, learned counsel, has filed their counter affidavit from the respondent numbers 1 to 6, represented by Ms. Vanesiami, learned government advocate, have not filed their counter affidavit. To stop as prayed for by the learned government advocate, further how much time?
3 weeks' time.
3
my
weeks'
lord.
time is granted for filing counter affidavit. Mr.
Obliged.
Jordan Romingthanga, learned counsel, appears for the petitioners.
Obliged.
Item 7.
Look, affidavit is still awaited from the respondents in this matter.
Yes, your lordship, on behalf of the state respondents, if I pray for 3 weeks time may be granted, your lordship,
Okay.
in order to file the AIO.
All right. Mr. Zoram Sana, learned counsel, appears for the petitioner, and Ms. Lanun Hui, learned government advocate, appearing for the state respondents, submits that she may be given further 3 weeks' time to obtain instructions and file counter affidavit.
Much
Prayers allowed.
obliged, much obliged, your lordship.
List
Like
again after
Madam.
3 weeks.
Item 8.
Yes.
Lordship, this appeal is preferred against the judgment and order dated 2/4/2025.
First appeal.
Yes, Lordship.
What are you aggrieved with? Civil suit.
Yes, Lordship. It was this judgment and order was disposed.
Your suit was dismissed.
Yes, Lordship.
Any evidence taken?
Some of the evidence were taken, Lordship, but they omitted the inspection and discovery of documents, that stage, Lordship. So
What is your claim in the civil suit?
our claim in the civil suit was for compensation of 50 lakhs.
For?
Compensation of 50 lakhs.
On what account?
The victim was electrocuted, Lordship.
Or electrocution?
Yes, Lordship.
Okay. Why was it dismissed then?
6 issues were framed, Lordship. Out of the 6 issues, the last issues, 2 issues, the first and second issues were framed by the learned predecessor judge. Then from the third issue, it was framed by a senior civil judge. Then for the relief claim by the petitioners,
I think simple thing is that you, according to the code, learned trial code, you failed to prove the negligence.
yes, Lordship.
That's why it was dismissed. I think at this stage we'll have to issue notice. Who are the respondents?
The respondents are the Power and Electricity Department, Lordship.
Okay. Heard Miss
Rosalind Elmar.
Rosalind Elmar, learned counsel for the appellant, who submits that being aggrieved with the judgment what is this? This is a judgment.
Yes, Lordship. Judgment dated 2/4/2025.
It is nowhere written that it's a judgment.
It is written order, Lordship.
Okay. What is this form number J2 and all that? There's a form for judgment.
Form number judgment 2, I suppose, Lordship.
There's a form for judgment, writing judgments. You have to write in the form.
No, Lordship.
And what is this form number J2?
I think it is a clerical mistake.
Why didn't you point it out before the person who have given you this certified copy? Please write, being aggrieved with the judgment dated 2/4/2025, passed by the Court of Civil Judge, Senior Division 3, Aizawl, in civil suit number 69 of 2009. Dismissing the civil suit, the appellants have preferred the instant appeal. Let the appeal be admitted. Call for the LCR. Issue notice. Returnable by 3 weeks. Ms. Lalnun Louis, learned government advocate, accepts notice on behalf of all the respondents. Appellant to serve requisite extra copies of the appeal petition to the learned government advocate, if not already done. List the matter along with the LCR after 3 weeks.
Obliged, Lordship.
Item 9.
In this case, my lord, by the impugned judgment order, 2 cases were disposed of by the learned trial court, which is heirship case and succession certificate case. And in respect of the succession certificate case, I have already filed 1 appeal, RFA number 6 of 2025, wherein the appeal was already admitted on 3/3/2025.
RFA?
RFA number 6 of 2025. Notice was issued and appeal was admitted on 3/3/2025.
When is the next date?
It was recently taken up on 2nd of May,
And?
and after 3 weeks to be listed.
Okay. Heard Mr. Victor L. Ralke, learned counsel for the appellant who submits that being aggrieved with the judgment and order passed by the Court of Civil Judge, Senior Division, Roman 4 ISO in heirship, in succession or heirship? In
The present one is heirship, my lord. The other one
in
is
heirship
succession.
case number 83 of 2018, disposed of along with succession case number 2103 of 2018, has preferred the instant appeal. The learned counsel submits that the appellant has already preferred a separate appeal in respect of succession case number 21 of 2000.
2103.
Sorry, in respect of succession case number 2103 of 2018 by filing RFA number 6 of 2025. And the same was admitted by this court. Stop. He therefore submits that the instant appeal may also be admitted and listed and tagged along with RFA number 6 of 2025. Next para, in view of above, let the appeal be admitted. LCR is already called?
Yes,
in
my
that
lord.
case.
It's being called.
In that case, called?
Yes, my lord.
So no separate order is required?
Not required.
No separate order is required for calling of the LCR. Issue notice. And who is appearing?
It's a private respondent, sole respondent. No one represented yet in the other case.
Returnable by 3 weeks.
Yes, my lord.
Appellant to take steps for service of notice upon the respondent. How will you take steps?
That's the my lord, if permissible.
By way of Dasti, through the registry of this court, within 10 days from today. Stop. The appellant shall thereafter file an affidavit as proof of service. List the matter along with RFA number 6 of 2025. What about stay?
Stay also granted in the other case.
Okay.
Not yet finalized, interim was given.
Then what to do with this stay?
In the same way, my lord, interim order.
Where's the order? Give me the order.
It's in the, I have enclosed in the IA. In my IA number 75 of 2025. Page number, running page number.
$46.
Yes, my lord, Annex 2. IA number 36 of 2025. This was issued on 3/3/2025 and which was thereafter extended on 2/5/2025.
Let's say last line. List again along with so and so. Okay. Next para, having regard, same order, having regards to the projection made by the appellant, it is hereby directed that the impugned judgment and order shall remain state till the next returnable date. IA will dispose it of.
Yes, my lord.
In IA, you write, in view of the order passed in the main appeal, the IA stands disposed of.
Deeply obliged.
Hearing item 11.
May please, Your Lordship.
Yes.
My Lord.
You want to withdraw?
No, my Lord.
Then?
I have been instructed to proceed with the case, my Lord.
Proceed with the case.
Yes.
Yes, my lord, there cannot be settlement.
There cannot be any settlement. What is the issue? That is regarding bank.
No, my Lord.
Loan.
Yes, loan.
Loan.
Yes. I have been elected as MDC. And my Lord, this is at annexure number 2, page number 15. I was issued certificate of election
Just a minute.
My lord.
The writ petition,
Yes, my lord.
page number 15.
Page number 15, annexure number 2. I have been elected as member of Changma Autonomous District Council from the 15 Rengkashia MDC constituency.
Yes, when was this?
And my lord, and thereafter, my lord, at page number 16.
19th of May 2023.
Yes, yes, my lord.
Term is for how many years? 5 years.
My lord.
Okay.
And after
Yes.
being issued this certificate and being elected as member of CADC, my lord, I have submitted one application. I, along with one other person who was also an elected member of MDC, we have jointly submitted an application for granting of loan for construction of house and advance for purchase of motor vehicle, which was otherwise provided by Rule 17.1 of the CADC Salaries, Allowances and Pensions of Members, Rules 2003.
All right, we'll come back in 5 minutes.
My lord.
Meanwhile, you bring out that CADC rules. Okay?
My lord, I have annexed the whole rule.
No, it's still
My lord.
5 minutes.
My lord. My lord, if I may
Yeah.
continue. Yes, my lord. So we were on page number 16. I, along with Mr. Nirupam Chakma, had filed this joint application under Rule 17.1 of the CADC Salaries, Allowances and Pensions of Members Rules 2003, which provides for sum of rupees 3 lakhs each payable in case of construction of residential house and also for purchase of motor vehicle. And my lord, the set rules is at Annexure 17.
There are two applicants.
Annexure, yes. However, only one applicant is before this honorable court.
Then what about Nirupam Chakma?
My lord, he's not before this honorable court.
No, that's the thing.
Yes,
But
my
has he received the loan?
No, my lord.
He has not received.
No.
Okay, Rule 17.1, where is it?
My lord, it is at relevant portion is at page number 21. Page number 21, if I may read.
Yes.
Grant of loan for construction or purchase of building and advance for a motor vehicle. Sub-rule 1. Subject to such condition and limitation as may be prescribed by rules, there shall be paid to a member A repayable loan for a sum of money not exceeding 3 lakhs rupees for construction of a building or purchasing a house, and B, a repayable advance for a sum of money not exceeding 3 lakhs rupees of the anticipated price, whichever be less, for purchase of a motor vehicle. And my lord, there is this rule has been amended in the year 2023. That is at page number 31, annexure number 7. The effective date is given. Page number 31, my lord. 31. Effective date is given at sub-rule 2 of Rule 1. It shall be deemed to have come into force on 1st day of April 2023. However, it was published in the Mizoram Gazette on 15/2/2024. And by this amendment, my lord, at page number 33, in the last paragraph.
Yes.
Amendment of Rule 17, if I may read.
Yes.
In sub-rule 1A of Rule 17 of the principal rules, for the words 3 lakhs rupees, the words 10 lakhs rupees shall be substituted. And 2. In sub-rule 1B of Rule 17 of the principal rules, for the words 3 lakhs rupees, the words 10 lakhs rupees shall be substituted. And pursuant to the amendment of these rules, my lord, I have submitted a fresh application. This is at page number 30, annexure 6. The sole petitioner, my lord.
Yes.
I have submitted this application.
When?
This is on 22nd April 2024.
So which one will apply?
My lord,
The old rules or the amended rules?
my lord, now the amended rules, my lord.
The amended rules will apply now.
Yes, my lord.
Because it is effective from?
From 1st April 2023. And I have accordingly submitted a fresh application, my lord. However, my lord, till today, this application has not been considered. However, my lord, the CADC had held a meeting. This is at annexure 5, page number 25. This is the forwarding letter, and the proceedings of the meeting is at page number 26. 26.
What does DG mean?
DG means dangu. It means kapu, pu.
Dangu.
Yes, dangu. It means pu. And by these proceedings, my lord, they have discussed and formed the terms and conditions for sanctioning of loan to members of the CADC. which, if I may read, my lord.
Yes.
Number 1, on the application for a building loan, a member shall execute a deed in the form prescribed by rules, undertaking to use the loan for the purpose for which it is sanctioned, rendering himself, oblique herself, and such property as may be specified in the deed as security, including the house purchased or built with the aid of the loan with interest due thereon, provided that no loan for building of the house shall be sanctioned unless the plot of land on which the house to be built is exclusively owned and possessed by the member applying thereof and is free from all encumbrances. 2. On the application for advance for a purchase of motor vehicle, a member shall execute a deed in a prescribed form, undertaking to use the advance for the purpose for which it is sanctioned, rendering himself, herself, and the motor vehicle to be purchased liable for the repayment of the advance with interest due thereon. Now, these 2 points, my lord, this is in respect of my loan application, my lord.
Your loan application for what purpose? For construction of house or
Yes.
for vehicle purchase?
And both, my lord.
Both.
Yes. So
So
I have.
you
I have
are
applied
eligible to receive 10 lakhs.
for, 10 lakhs each, my lord. So total will come to 20 lakhs rupees.
10 lakhs each.
Yes, my lord. Since my application was for construction of a house as well as for advance motor loan. Page number 30, my application in the last line, my lord.
Page number 30.
Yes, page number 30 in the last line. If I may read the last paragraph.
Yes.
In compliance with the rule referred to above, I, the undersigned member of the 11th CADC, would like to request you to kindly grant me a loan of rupees 20 lakhs for the purposes mentioned herein. So, my lord, however, despite of...
Who will give you the loan?
My lord, I have applied to the chairman of the CADC.
No. The district council is not a bank.
Yes, my lord.
Who will give you the loan? Which bank will give you the loan?
My lord, this will be sanctioned by the CADC, and in whichever bank account that I have, that will be sanctioned, my lord, as per the instructions that I have.
No, CADC has a control over the banks. That whenever we recommend you issue loan. Can they say that?
My lord, they will issue this loan approval, and that will be given to the respective banks to which the applicants have bank account, my lord. And my lord, the stand of the respondents is that now, as of now, loan cannot be sanctioned because the CADC lacks funds. That is basically the.
No, see, what I was saying again is that the CADC is on the recommending authority.
My lord.
They'll recommend for sanction of loan.
Yes.
But the district council itself is not lending the money. It will be lent by the bank, isn't it?
My lord.
So what sort of arrangement do they have between the CADC and which bank? That whenever they recommend, they'll sanction loan.
My lord, that particular subject, my lord, I have not received any instructions.
But that is how things are to proceed. Normally, when you want loan, you go to the bank.
My lord.
But here you want loan, and you say that I'm a member
Yes.
of the district council, and as per the rules, I'm entitled to obtain loan. So, which bank will give you that loan? The CADC must be having a tie-up with some bank. Which bank is that?
My lord, that has not been reflected in the
Mr.
in the rules.
You know that?
My lord, I do not have the instruction in that regard because the rules just say members are entitled to such loan.
Your instructions are not complete then.
My lord, the difficulty is the reason why we are not giving him a loan is as stated in the affidavit, we do not have funds to give loans. And his application for loan has not been refused as of now.
Where is that?
It's still under consideration, Madam.
Where is that?
I have stated in paragraph 5 and 7
Please read paragraph 5.
that with regard to the statement made in paragraph 3 of the petition, I say that the application for the petitioner's application for granting of loan is under process, and the response of the chairman of the CIDC is awaited pending the preparation of guidelines and regulation of sanctioning of loans to members of the CIDC. Further, the CIDC is currently facing financial constraint and is unable to pay loan to each member for construction or purchase of building and advance for a motor vehicle.
Just a minute. From here reading.
Paragraph 5 of the affidavit.
Yes, that.
The CADC is preparing guidelines and regulation for payment of loans to each member, which will be finalized in due course, and it is expected that CADC will be able to pay loans on receiving revised estimate from the state government. This is our submission, my lord. But till date, we have not received the revised estimate from the state government, due to which we are not in a position to give loans to any members of the current.
What is this revised estimate? Revised estimate of what?
Revised estimate, yes, there is a budget estimate, and revised estimate is also to be given by the state government to the CIDC. That is
Budget.
the instruction that I have obtained.
Budget.
Budget, yes, revised estimate from the state government. So that is the current position, the financial constraint. My lord, the petitioner himself is now in the government side. At the time of making an application for the loan, he was the opposition member. Now he is in the ruling party. He is the advisor to the CEM, the current CEM. He must know the financial position of the CADC. We are not refusing his application. We are not rejecting. We admit his entitlement. But the only problem that we face is the financial constraint.
Your basic stand is that you have not rejected.
My lord,
Only thing is that there's some financial constraints, so you have not replied.
my lord.
Since you have not replied, that's why he has come before the court. What is his guidelines?
Yes,
What are you talking about?
the instruction that I have received from the respondent is that they are preparing the guideline, because they said that they do not have the guidelines for this kind of sanctioning of loan. So they need to make and prepare specific guidelines for sanctioning of loan to the members, and that will be finalized in due course. Plus, the receipt of revised estimate from the state government is required by the CADC, so that it can sanction loans to the members as per their entitlement.
When are you framing the guidelines?
My lord, I have personally asked the respondent number 1 whether they have finalized the guidelines. I was informed that due to non-receipt of the revised estimate, that the guidelines also has not been prepared and finalized.
Revised estimate, you say, you talk about revised estimate, you talk about revised guidelines. But what are the facts and figures that you have not said? When did you ask for revised estimate and what is the amount?
My Lord, if I may submit a government letter, asking the state government with regard to the requisition of revised estimate. I have the paper, my Lord.
No, not like that. You should file it. Why didn't you incorporate it in your affidavit?
My Lord, I have recently been informed this, sent this one, only recently, my Lord.
So, regarding revised estimate and regarding guidelines,
Guidelines to be prepared, yes.
doesn't you don't have any guidelines?
My Lord,
Then what about this meeting minutes?
My lord, my humble understanding is that this has been specifically, this meeting has been held specifically to decide on the conditions as reflected at paragraph number 2. It says that this is as per the my application. Actually, pursuant to the application filed by myself and another member, one Nirupam Chakma, this meeting was held. And the terms and conditions, my lord, the guidelines were decided by this meeting, my lord.
terms and condition
And even, my lord, my lord, my lord.
In terms of the meeting minutes, as decided by the meeting, these are the guidelines. So you already have set the meeting for the guidelines. Why are you not notifying them?
Well, this meeting minute is also silent about the framing, preparation of the guidelines. The terms and condition in respect of sanctioning of loans to the members.
After elaborate and detailed discussions, the following terms and conditions in respect of sanctioning loans to members of the CADC were unanimously considered in the meeting. So point number 1, 2, 3, 4, 5. So these are basically the guidelines. What is their response to this affidavit? I mean, to this meeting minutes. What is the annexure? Annexure 5.
My lord,
It is annexed against which paragraph? Annexure 5.
this is at paragraph 5, page number
5.
7. Page number 7 of my
And what is the reply against paragraph 5?
Paragraph 7 of my affidavit, my lord. If I may read, my lord.
I've read it. You have filed this affidavit in November 24.
My lord.
Now it's May. Half a year has gone by now. What is your latest instruction?
Yes, the instruction that I have obtained is they have not received the revised estimate from the state government. They are still unable to sanction loan to any of the members. And before yesterday also, the respondent number 1, who is the executive secretary, has personally met the petitioner number 1, petitioner who is the advisor to the CEM, the current CEM. But the settlement cannot be arrived at.
Settlement means
Settlement means whether he can withdraw his application for the loan because of the financial position of the CADC right now. So, if they receive, my lord, as per the verbal information that I received, if they receive funds from the state government, they have no problem in the sanctioning loan to the members. And my learned friend has submitted the terms and condition, point number 1 and 2 of the meeting, my lord. It appears that even though I have not stated in my affidavit, his application, page 30, is not accompanied by a deed to be executed by him. On application for a building of loan, a member shall execute a deed in a form prescribed by rules.
deed is as per what?
Deed.
Meeting minutes?
Yes, my lord.
And the
sample is at page number 29 of
page
my petition.
29.
So
His application is not accompanied by the deed executed by him.
but the meeting minutes also has not been given a formal
My lord.
what do you call, color, so that everybody can apply as per the notification. This is only a meeting minutes.
Right.
Are you not planning to make this, notify this terms and conditions? Please call the steno. You file an affidavit, we'll see. We'll post it again after some time.
My lord.
Give some more details about your guidelines and the revised estimate, you said.
My lord.
Revised estimate means what? Revised budget?
Revised budget, yes, my lord.
What is the name of the rules called?
My lord, this is Changma Autonomous District Council Salaries, Allowances and Pension of Members Rules, 2003.
2003.
Yes, my lord. And the subsequent amendment, 2023.
Amendment.
Please write down. The petitioner is an elected member of the Chakma Autonomous District Council, bracket CADC. We'll stop. In terms of the relevant provisions of the Chakma Autonomous District Council, open bracket, salaries, comma, allowances, and pension of members, close bracket, rules, comma, 2003. And its amendment. In 2023. Comma, a member of the CADC is entitled to avail loan for a sum of rupees 10 lakhs each for construction of a building or purchasing a house and for purchase of a motor vehicle. Stop. Despite the petitioner having made an application for sanction of loan, jointly with another member, CADC, on 2/6/2023, and individually on 22/4/2024, comma, since loan has not been sanctioned, comma, he is before this court through the instant writ petition. Next para, the respondents have filed a counter affidavit wherein it has been contended that it is contended that they have not rejected the application of the petitioner for loan. Intention of this court to the meeting minutes dated 12/7/2023
12 July, 12 July 2020. 12 July 2020.
12/7/23.
Okay, 3 weeks, right, my lord? My lord. My lord.
My lord. Yes, my lord. My lord.
The other member is not saying anything.